Alrighty, good evening, ladies and gentlemen. This is the Newbury Zoning Board of Appeals. It's February 15th, Thursday night. We're here at Kent Way, and we have to my left Martha Taylor, our town planner. We have Chrissy Beaupre, who is our administrative assistant. We have at the far right Larry Murphy, who's our liaison to the planning board. Jack Kelly, who's a member of the board. Michelle Wheeler, who is an associate member to the board. Mario Carnavale, who's a member of the board, and myself, Eric Spahn, who's chair of the board. I'd also recognize that we have Peter Bennett in attendance, who is our town building inspector. So, with that, we're going to open it up, and we're going to go a little out of order because we're going to try to move one along quickly, and then get back to the order. So, Mario, if you would.
Okay, first, Mark and Teresa Ritchie, 10 Fordham Way. The applicants are requesting a special permit finding for relief from section 97(4)D 5C0101, increase in square footage of the Newbury zoning bylaws and any other permit relief as may be required under the town of Newbury's zoning bylaws to allow the proposed use project in order to raise the existing structure, 8 Fordham Way, merge the two lots at 8 Fordham Way and 10 Fordham Way into one lot and construct an addition on the existing single-family dwelling to remain on the newly combined lot for the property located at 10 Fordham Way, Assessor's Map U01, Lot 20, and 8 Fordham Way, Assessor's Map U01, Lot 21.
All right, is the applicant here?
Good evening, Matt Steino from Millennium Engineering. I'm here tonight just to ask the board to continue this case to your next regularly scheduled meeting. Unfortunately, due to us rushing and the office staff doing a phenomenal job trying to help us get this in at the last minute, we made an error on the abutter notification. We have to redo the abutter notification. So just so there's no problems, moving forward with the public hearing, we want to make sure that's taken care of. So we're going to need to continue that.
Okay, so we're going to need a time and a place and a date. Obviously, the place is here. The time would be 7:30.
21st?
The 21st is the third Thursday, but I will be out of town. So we could do it on the 14th or the 28th.
14th would be good for us. I'm okay with the 14th.
Okay?
Yes.
Chrissy, are we okay with the 14th, do you think?
Thank you, Martha. See if there's anything. That's okay. Bear with us just a second. Don't want them.
Just making sure we don't have to meet outside.
Still cold, though.
Just a minute to navigate through here. So 14th, looks like there's no regularly scheduled meeting here. I can't check the other calendar.
I can book that tonight when I go back down.
Great.
Okay.
Is there a motion?
Yeah, I'll make a motion to continue the decision till March 14th, 7:30 here at Town Hall.
Second?
All right, all those in favor? Aye. Thank you. All righty, Chrissy. Book that, that'd be great.
Number 2, Tim and Anna Drost, 76 Northern Boulevard, property at 880 Northern Boulevard. The Office of Attorney Jeffrey L. Rolfs has filed a notice of appeal on behalf of Tim and Anna Drost of 76 Northern Boulevard against the Town of Newbury's Director of Inspectional Services for his zoning enforcement decision dated November 29, 2023, issued to the wards of 80 Northern Boulevard as being legally deficient. This appeal is brought pursuant to Mass General Law 40A 815 and the Town of Newbury zoning bylaws 9711B with regards to the property located at 80 Northern Boulevard, Palmyra, Mass.
All right, the applicant here?
Yes, good evening, thank you. Jeff Roloffs, counsel to Tim and Anna Drost at 76 Northern Boulevard. I do have some slides if it's okay for me to present them over here. I may just pull up a few and then come back to get in front of you. So this is an appeal of Mr. Bennett's enforcement order.
You can make that larger.
Yes.
On the projector, on the way, on the right, bottom right, there's a little projector symbol,
Yeah, there's another way to do that, yeah.
right there. Okay, right. If it helps.
Yeah, we're slide, just,
Wow, this is gonna get, when you're not on your own hardware, it gets confusing. All right. Let's see if I can get out of that mode. Let's try this. So, basically what we're looking at here, which is not that important, is just the top cover page of my letter. You have this in front of you. I wanted to walk through portions of it. I wanted to get to the photos, if we can get to those, because I think it'll be helpful to understand the property and use that to walk through it. But by way of introduction, while the computer is thinking, whoa, sorry.
do you want to talk and I'll take a look and see?
Yes, I think that'd be great. And Mark, I'm just trying to tee up that photo. I think the rest we can cover through the packet that you have in front of you, and I'm gonna just walk through some of those points. But basically, the appeal here is of one aspect of Mr. Bennett's determination. So we had requested enforcement, arguing that at this property, there's an illegal second dwelling unit. Mr. Bennett reviewed the issue and he agreed with us. The original house at this property was built, I believe it was in the early 1900s. A garage was built in approximately sometime in the 1970s. At some point in the 1990s, the rear portion of the garage was retrofitted with a kitchenette, a bath, and living areas. No building permits were secured, no occupancy permits were issued, no inspections were conducted, and Mr. Burnett confirmed all of this in his determination, which is attached to our appeal. So he agreed with us that this living area behind the garage constitutes an illegal second dwelling unit. At least that's how I interpreted his letter. He's obviously here, so he can speak to that if I missed it. The cease and desist order he then imposed, based upon that finding, prohibited the owners from renting that space to others. But it allowed the continued use of that space by the owners of the property and presumably their guests or anyone else who's a non-renter. And it's that aspect of the decision that we object to. So I'd like to just walk through, if you have it, you could walk through it with me. But the grounds for our appeal are set forth on page 2. What I first do is I refer back to our initial enforcement request, which is also included here, because the enforcement request that we submitted in November provides additional details related to the background, when the structures were constructed, how they were used, etc. It also contained a section conveying or communicating the basis for our argument that that unit is an illegal second dwelling unit. And then third, we made the argument in our initial request that the use of the second dwelling unit as a living space, even by the owners or their guests, is not permitted and it's illegal. We then included some photographs of the structure, which you have in the materials in front of you. You can see on page 3 there that this is a view of the house. The larger photo is a view of the house from the beach, sort of an aerial view, with the main house on the left of this photograph, the garage on the right with the retrofitted living area, second dwelling unit to the rear. And then at some point, there was a connection made between that second dwelling unit and the main house. That's a breezeway. It's unheated. It's not a living area. All it is basically a porch with a roof put over it. It's a breezeway. I then go on in our appeal to enumerate certain points, and I numbered them because I think it's really important on this analysis to sort of tease apart the different aspects of the legal issues that are presented here. So, number 1, there's no legal basis for the distinction, as suggested in Mr. Bennett's decision, between use of this illegal second dwelling unit by the property owners or their family or guests, and the use of the illegal second dwelling unit by renters. So he drew a distinction. I'm interested in understanding more as to why he thinks that that made sense. There was no explanation for it, but in my opinion, based on my review of the law, it doesn't matter who's using the space. It's an illegal second dwelling unit, and it's illegal whether it's used by the occupants of the main house, their guests, or renters. Point number 2, which is on page 4 of our appeal, goes on to explain that the illegally converted garage space is not within or simply an extension of the single-family residence. Among the other characteristics noted in the DROS, our initial enforcement request, the second space includes independent living facilities. It has a separate ingress and egress points. It has been used and rented historically as a second dwelling unit, and it's separated from the single-family residence by an unconditioned, screened-in breezeway with no common wall. It is essentially a detached second dwelling unit built and used without any permits or approvals. It was illegal when it was built, and it's still illegal today. The third point we make is that under the sort of what people refer to as grandfathering provisions under state law, Chapter 48, Section 6, as well as the similar PIOD grandfathering provisions, there are grandfathering protections afforded to pre-existing uses and structures. But the protections only apply to pre-existing uses and structures that were lawful when they were started. So in this case, they weren't lawful. They weren't lawful because they weren't, either the use wasn't allowed and or there were no building permits or occupancy permits issued for the use. So this isn't a situation where you had a lawful use and then the PIOD provisions were adopted, and therefore this would be a lawfully pre-existing non-conforming use that they could continue. It's not that, because it was an illegal use when it was started, and it's still illegal, and even more illegal once the PIOD provisions were adopted. So those protections don't apply here because it was unlawful from the commencement. Under Chapter 48, Section 7, different provisions, these provisions, Martha, I don't think it's worth it, don't worry about it. Under 48, Section 7, there are provisions that provide protection to certain uses and structures if enforcement isn't undertaken within certain time periods. For structures, and there have been relatively recent amendments to it, for structures, if you have built a structure and no enforcement was initiated for, I think it's 6 years, then that structure, actually 10 years, the structure pursuant to Section 7 is deemed to be a lawfully pre-existing non-conforming structure. That's the structure. That's different than the use. And we're not arguing that they need to take down the structure, just to be clear. So the structure is protected by this provision in Section 7 because no enforcement was initiated within 10 years of its construction. The use, however, and the use protections provided by 48 Section 7, again, only apply to uses that were lawful when they were commenced. These uses, the use of this space as a living area, wasn't lawful when it was commenced, and it's not lawful now. So Section 7, and the fact that more than 10 years has passed since the use began, doesn't provide them any protection. That's point number 4. Point number 5, even if the illegally converted space were viewed as merely an extension of the single-family residence, so if you ignore the fact that it's separated by this unconditioned space, even if it was just an add-on to the existing house, the use as an additional living area would still be unlawful because no building or occupancy permits were issued when the extension was built. And I'm going to get back to that point, but that's point number 5. And then finally, 2 more points. Point number 6, and again, I numbered these because I think we need to tease these apart, and where we have disagreement, I'd like to be able to identify where that is. Point number 6, even if the illegally converted space were viewed as an extension of the single-family residence, and even if its use as additional living area were authorized, which we dispute, the use of this space as an additional bedroom, bringing the total number of bedrooms at the property to 5, would also violate the bedroom constraints of the PIAD. As you know, because you apply the PIAD provisions, the PIAD only allows additional bedrooms by special permit up to a maximum of 3 bedrooms. So this is important because it was not long ago where the wards were in front of you looking to expand on top of this illegal space. And we raised the point then that the space was illegal, and the board basically said this isn't the forum for those issues, that's an enforcement thing you'd have to bring separately. So, but it's important to understand that the wards had used the presence of bedrooms in this space as a way to try to leverage future expansions. They did it a few years ago also where they were, I think, proposing to demolish the whole thing and rebuild it. And I believe in that context, the proposal was a house that had 5 bedrooms, again, leveraging off of their view that not only do they have 3 or 4 bedrooms in the main house, but they have bedrooms in this additional illegal space, and so they're trying to take advantage of that. This isn't personal against the wards, by the way. This property is listed for sale. This issue pertains to the property, and it's an important issue for us to get right as part of this process so that any buyers and future owners and occupants know what they can and can't do with the property. Point number 7, unless the owners decide to pursue and actually secure the permits and approvals necessary to use the illegally converted garage space as an additional living area, they should be required to remove the kitchen and plumbing facilities that were illegally installed without any permits and that support the ongoing illegal use of the space. This is the remedy that we're asking for. Attached to our appeal and discussed further in our initial enforcement request is a land court decision, which if you haven't had a chance to review it, I urge you to review it because it's a case that came through the land court 2011, and it presented a situation that was almost identical to this one. It was a seasonal cottage on the beach, a second a garage structure that had been converted to include some living areas. I mean, the facts line up very closely with the facts that are presented here. Ultimately, the land court judge concluded that because the living area that was constructed in the garage had never secured a building permit or an occupancy permit, no inspections were done when it was constructed, no plumbing inspections, no wiring inspections, there were no determinations ever made that the space was habitable or safe for occupancy. Because the use never received the benefit of those safeguards, the permits and inspections, it was an unlawful use when it was started, and there's no grandfathering protections that apply to render it now lawful. So the ZBA in that case had actually made the same finding. It was the owners of the property that appealed it to land court. The land court supported the ZBA's conclusion that the use was illegal. It was an illegal second dwelling unit, just as this one is, and the court ordered them to remove plumbing, kitchen facilities, plumbing, and any connection to septic. Basically, the structure could remain intact. The structure itself is grandfathered. The use is not. So they needed to render it an unlivable space by removing all of those features. Presumably, it could continue to be used for storage as you would for your, the back end of your garage. So that's the remedy we're pursuing here. That Boyd decision is attached to the appeal as Exhibit C to the original request for enforcement, and it's directly on point. I did have some photos in my presentation. I don't think it's important, but I had some photos that I pulled from the Zillow listing that I found today. I will say, when we filed our request for enforcement, the property was listed in a way that actually articulated that, I think it listed the property as having basically 2 units. I don't have the words in front of me right now. The listing I saw today seemed to correct that. But it did carry forward photographs of the illegal space, including pictures of the kitchen, the bathroom, the bedroom, the living area associated with the kitchen. It's dedicated as a living space. and it's being marketed that way. It's an illegal use, and it should be ended. The final point I'm gonna make is, I understand in Plum Island, there are a lot of interesting land use issues out on Plum Island, and I think Mr. Burnett may have been reluctant to impose or issue the order that went as far as when we were looking. What I wanted to point out on that topic is, while I understand the reluctance to pursue strict enforcement with these laws, given that there are a lot of probably discrepancies out there in the island, I think the more dangerous issue that you should be thinking about is the precedent you're gonna set if you conclude that this illegal use can be continued. Because if you conclude that here, I'm sure there are a lot of other similar types of uses on Plum Island and owners that are gonna find comfort in a ruling like that. So I can see both sides of that. I just wanted to get you thinking about that other issue. Thank you.
Thank you. While you're there,
Yeah.
any members of the board have any direct questions at this time?
I have one. So I'm interested in your argument. I think you did a good job. Point number 4. Your point is that it's the, you don't have any beef with the structure under the 10-year exemption. It's the use that's not permitted. That's what you're arguing.
Correct.
So my question is, you say that you're suggesting that it should only be used for storage. That's what it
As
says.
an extension of the garage. That's right. Correct. I mean, there may be other similar types of uses. I don't know. I guess depends on what you had in mind. But yes, basically right.
I'm just trying to get a grip on it. So am
Yeah.
I allowed, if I buy this house, I don't think I'm going to, but if I were to buy this house, am I allowed to walk through it from the main structure to the garage?
I don't see any reason why it can't be used as a hallway, a covered, essentially. I mean, from the main house, you go through the breezeway. I don't think we would have any issue with keeping the doors there and having it be a space that you can walk through your garage.
Okay, in a similar vein, I should be able to walk through from the northern boulevard side and come out on the beach side. There's doors on both ends. Do we have a beef with
I
that?
don't think we have any problem with that either.
Okay, so here's where it gets tricky. Can I stop, let's say I'm carrying a Polar Seltzer. Can I stop in front of the windows and look out at the beach, perhaps even sit down and drink my Polar Seltzer while I'm looking at the beach?
You want a TV too.
Now, I haven't got there yet. It's a line.
Oh, yeah,
Like a
I
line of pushing.
Yeah, that's
No, I
sort
think
of-
Can you
that's
watch
my last
TV
one.
in there?
I think in the transient question and pausing in the space, I don't see a problem with that. I mean, if you
But
have
no
a storage space, or even your garage, sometimes your garages around here have windows on the back side so they can look out to the Merrimack or the ocean or whatever. If you want to set up a workbench and work in your garage and look out the window, I don't see a problem with that. There's going to be a fine line that you're getting to as to where you walk from a garage activity to a living space. A garage is not a living space, even though I spent a lot of time in there playing ping pong with my son and fiddling at the workbench, so I get it. It's not crystal clear, but it is clear, and you don't have to necessarily define the parameters in this decision. I think it's enough for you to make it clear that you can't use this as a living area, and that you need to remove the plumbing and kitchen facilities that have been installed there unlawfully and that facilitate its use as a real living area, bedroom, kitchen, etc.
But you're not asking to remove the heat. Again, just
It's
sort of
a good question.
to
We
tag on
are
to
not
that.
asking them to remove the heat. I think that we actually talked about that. If somebody were to put in a heating system in their garage so that they're storing photos in a sort of air-conditioned space, I haven't wrestled that issue down, but we're not asking for that remedy. The remedy we're looking for is removal of the kitchen items, all the kitchen appliances, and the plumbing, which includes the bath and shower.
Thank you.
All right, thank you.
Thank you.
Mr. Burnett, would you like to come forward and explain.
Well, I will. Let's see,
Letter,
I left
please.
my PowerPoint presentation at home.
Thank you.
But I will do, I mean, I'll just give you the nickel tour of where I come from on this. I got the initial request for enforcement, and I looked into it and went and met with Mr. Ward at his place. And while I agree the use is not grandfathered and not proper, the use is established by the fact that they rented it. Now, the enforcement order says you not to rent this either full-time or seasonally, as a verbal or whatever it is, whatever they call them nowadays. So that, I mean, I think that took care of that part of it. But the fact of the matter is there were no permits, but there's no record of when this work was done. So the way I look at it, it's past 10 years, and it's now, that is established space. So that space is not the issue, it's the use that is the issue. And I think that this is where we disagree, is I didn't agree or consent at all that this was a second dwelling unit. I think by renting it, it created that use, which is an improper use. So, I mean, as far as the building code goes, the provisions of the IA define a 101.2. Existing dwellings that are legally occupied in accordance with that at the time the ISC is adopted. I don't know when we adopted the ISC. I don't know when this was constructed, remain unchanged and not subject retrospectively to the provisions of the code. So, unless I have a specific date in the code that was adopted, because the code changes every 3 years, can be the 9th edition, can be the 7th edition, whatever. There's no way of knowing that. So that part of it is, it's an existing condition, and it's an existing space. So I don't know, I may not be explaining myself very well, but the space isn't the issue, the use was the issue. I agree that it was improper, the use, and I think the enforcement order took care of that. I think the space, I think we're to order to go in and start tearing things apart in a space that is, in my opinion, not subject retrospectively to the code is a little extreme. So that's where I landed. I don't think it's legally deficient. I think it's legally common sense, but that's just me.
I have a couple questions for you. So, it's unfortunate that the structure was built in the location that it was built in the way that it was built. But I think we might all agree that the structure has been there for 10 years. And I don't know how else you look at it except for, I don't know, somebody can provide a photo to us and or somehow assessor's cards can show a change. So if the structure is there and the structure remains, and we talk about the use, and we talk about removal of plumbing, and we talk about the use of a rental, the use of a bedroom, the PIOD recognizes the number of bedrooms in a unit.
Right.
The number of bedrooms is what drives the use of plumbing fixtures. You can have as many people in your house for a gigantic party as long as they're not that can fit, but they all can be using the plumbing fixtures. It is the bedrooms, though, that determine morning, afternoon, and evening use. So even if you were to remove the plumbing, you would still have a bedroom, and you still would have a room. That room still could be used for a bedroom, and that bedroom would then still be used for the number of occupants, or would be seen as used for the number of occupants that are using or taxing the plumbing fixtures in the unit, right? I was going and had the same thought, that if the use of a bedroom and the thought of a bedroom being habitable and the bedroom limiting the number of people, then the removal of the kitchen is not here or there for the number of fixtures. The kitchen does add to the waste and the sanitary that's going out, but it is the bedrooms that drive the thought of what the load is.
Well, that's how, yeah, right, that's what they're gonna try, you get them on the floor on something, and they're gonna use bedroom.
Okay. So if the pipes were removed and the heat was removed, then you wouldn't have it as a, quote, bedroom. Also, I don't think we're all trying to figure out how to qualify what a space is.
Right.
We can judge use all day. In terms of the bylaws and the understanding of what the bylaws are trying to do and the leeway of how the bylaws allow us to view what is proposed to us in the standards and metrics of the PIOD and the adjacent neighborhood in terms of being more or less detrimental. So also then, if we are coming to terms with what a space is, we don't have means of enforcement of that, right? So if in how we move through this, understanding how we limit it. So I think you're clear that you're saying that your action, and if the board all understands and agrees, that the purview or the view of the building inspector is the action of renting that is non-conforming, and it's not the fact that it exists as a bedroom is not detrimental, right? And the argument from the applicant is the fact that there is a kitchen in there adds to or promotes the use of a bedroom, which is detrimental to the use, and explained how that use is not detrimental because of when it is, and trying to separate the structure from the use. And it's, our purview and simple purview is the protection of space and air, and to not exacerbate the density on the island. And so density on the island is also viewed as bedrooms and number of people, and that also relates to how the PIOD came into effect in terms of adding the sewer and trying to make sure that the sewer at some point was not overtaxed, and that the sewer had some limits to it, and therefore the limits are put on the property by the number of bedrooms.
Right. And that, I mean, that's a difficult thing to figure out too. I will say that I went to I've been there a couple of times and did a couple of inspections. In the main house when I went, I saw 3 completely set up bedrooms upstairs. Downstairs I saw a kitchen, a living room, and an office, in a vestibule room that wasn't heated, that was basically, it was a good size entry, but it was basically storage. And then this connector bedroom was the 4th bedroom, which they were allowed on the tax card. Now, I mean, it's difficult to, what's a bedroom? So that gets tough, but that's all I saw, was I saw three 3 fully made-up bedrooms in the main house, and this one small, small, very small space in there. What I do have the ability to do during an inspection, even though it's retroactively, it's established space, is if I think a life safety issue is at hand, which I did, and I notified Mr. Ward that before he can use that space, period, there needs to be fire separation between the garage and that room, which that's within, my right.
Right, so it's a garage and you have occupiable
Right.
living space.
Right,
It's just living space needs to be separated from the garage, period.
right. And no access from the garage directly to a bedroom, no, in fire separation. Those are life safety things I can order them to do, which I did.
Yep.
So that's interesting because the assessor card lists the main building, built in 1900, as having 4 bedrooms. And also the pictures provided by the attorney listed as, in opposition, as 4 bedrooms. So I guess that's one question.
Yeah, I mean, I'm just telling you what I saw.
Sure, that's your job.
And whether it is or not, doesn't, at the end of the day, I don't think, doesn't affect the fact that it's established space. If that's, in one of my letters to him, I specifically said in the letter that if that small bedroom establishes a 5th bedroom in the house, it has to be removed. So that's when I went back and walked through the house, and, I mean, that's, I saw what I saw, but
Just gonna ask a question, but when you come from the house to the breezeway, where do you end up? In the garage, behind the garage, in the?
you go through the breezeway to, the door will bring you into like this little alcove kitchenette.
You don't enter.
You don't
directly
enter the
into
garage? Yeah, okay.
Right, well, you can get into that little bedroom through the garage. That's part of my enforcement order for
Okay.
the fire separation. But I guess what I'm saying is that I don't know, I'm not arguing the bedrooms as much as I am the established space.
So in the past, an applicant submits for a building permit to you.
Right,
You look at the PIOD, and for several reasons, things get flagged and they need to come to us.
right,
And sometimes there are just general issues of upward expansion that come to us, and then there are additional questions that we have above and beyond what you had cited in order to bring them to the ZBA.
yeah,
In that, we also have been instructed that in terms of what is submitted to us, that we are to take it as face value as to what is submitted. And we have, understanding that, pushback on some applicants because it looks like a duck, it smells like a duck, but they're telling us it's not. And we have had discussions, and you can look at the record, and we've had a couple where we've basically said we're not, we're just not in agreement. Or if certain things were done, you would do that. Also, we've seen offices that look fairly suspicious as a bedroom, and due course of action, if it's an office and it's listed as an office, we're supposed to take it as an office, and we ask them to remove the door or create a larger opening. After that, we don't have control of it because we're not the enforcement officer and you are. So we do come across difficulty in understanding what we think people are presenting to us. The fact that it's on record for being advertised as such, and the fact that it is for sale and may be represented as such in advertising does not bode well for, or it gives us additional understanding and leverage to say that is not what is on the piece of paper.
Right, and that's problematic, and I've made that clear to them.
And we've, not duped, but we've, a little bit of misrepresentation in looking at a plan and not understanding of what something is labeled, only to have somebody stand up and provide documentation that space is being used as a rental or a bedroom or others. And so it's with that we, the board, if I can speak for the whole board, have the concern and purview as what's being presented and what it's actually intended for. And if we're trying to enforce, or we're trying to make a decision about what somebody's presenting to us, they're coming for us for approval. We're looking for you for enforcement, and we're both trying to figure out what meets the intent of the bylaw for the benefit of all the residents of Newbury. So I think we have a little bit of a gray zone to understand and chew on. And the fact that the 10 years went by may make it a legally non-conforming structure today, but it still has a very sour taste as to its existence, the fact that it's built over the property line, the fact that it's been advertised as a rental, and the fact that it looks like a rental in every way, shape, and form doesn't sit well. But we have certain bylaws and certain means that we can judge and act on, and you have certain ones. So this makes it even a little more difficult that someone is appealing your judgment and now it's back before us. And so now we're in the position, I think, of understanding your enforcement and enforcing ourselves. So,
I mean, my main concern, Eric, was the use, which we've been through. By leasing it, it established a use that wasn't allowed or wasn't appropriate. And so my enforcement order dealt with that.
And we don't want it to be sold as,
Correct.
that's I think,
And
an important
that was
issue.
another thing that we talked about, and I asked them to take down whatever ads they had up that weren't correct. And
So-
I'm assuming that they're down, but
how much enforcement is there, or are you able to do if, I mean, you're not driving around looking for enforcement. We're not driving around looking for zoning issues just to bring them up. It's usually brought up by neighbors or people that have concern, and those neighbors are in the immediate neighborhood of protecting their property and their property values by somebody that's doing something that they deem is not allowable. So, so we're also, I mean, we're just, I think anything that we do, we want, at least the board has always been saying that in terms of, especially at Plum Island with the nonconformities that exist out there, that we're always looking for improvement of a property. That anything that comes before us that is presented that exacerbates the condition is a non-starter. If it maintains it equally, even if it's non-conforming, isn't great. But if it shows improvement of those non-conformities, then it's favorable, and that's the basic guidelines of the board, or that's how the board has acted. So I think the understanding your position that the use is based on the rental and not of just the space. And Jack asked a question that took it a little further of exactly the use. And what's been presented to us fairly clearly in the numbered arguments. I think the board, so appreciate what you're presented and what's been presented to us. And at this point, I'd ask the board that we have a discussion amongst it. I don't know if anybody, are there any questions for Mr. Banana?
Oh, thank you.
Good.
Thank you. Are there any members of the audience that are here that would like to speak in favor?
I'd like to speak on behalf of Mr. Ward. My name is Tyler Sheets. I'm attorney with Finnerty Nicholson. I'm here filling in for Doug Deshane, who you're familiar with. Doug is not feeling well, he's in the hospital. It's recovering.
We wish you the best.
Yeah, thank you. I'll relay that to him. There's a few things that I'd like to address that I think are statements of fact that are vaguely assumed and implied that there isn't a basis for. One of them is the suggestion that this bedroom is added onto the back of the garage in the 90s. There's no basis for that. It's Mr. Ward's understanding, and the Ward's understanding has always been that it was built 50 years ago, in the 1970s, and that bedroom has existed there for 50 years without anybody complaining about it. The neighbors have lived in the property half of that time. So over the last half century, no one's complained about this bedroom existing back there. And it's been used as, and the Wards have not used it as a rental as a separate dwelling unit at all. They've rented it, but they've rented the entire house together, including the breezeway that connects the properties and all of that. And the reason why it matters whether or not it's being used by a single family or whether it's being used as a single housekeeping unit where the rooms are connected and there's egress and ingress from room to room throughout the entire house is because of the idea that you don't want to be taxing a house as two separate dwelling units because you're essentially having two lots that aren't on two lots. And the concept of having a single housekeeping unit is that it is more efficient and you're taxing less of the resources, plumbing, etc. The fact that the plumbing has been there without any complaints for a half a century and that it's coming up now where the Wards didn't install any of this stuff without a permit. And when we're talking about it not having a permit, the citations in points 1 through 7 of this letter are referring to the Plum Island Overlay District regulations, which didn't exist until 2001. So when it repeatedly says in this letter that it was unlawful from the beginning is 30 years before these rules even existed. So how could it be unlawful under a law that didn't even exist? So there's a few misnomers in the way that this is being presented. And I think that a lot of the misunderstanding and the conflict is partly coming from the fact that we don't have that information as to when the exact date that these things were built. They were built during a time when there weren't as many regulations as there are today about, everything. Populations grow, we become more concerned and aware scientifically about how we're impacting and taxing each other and affecting one another. And those things didn't exist in the same way when this unit is added onto the back of the garage. I think from the picture within the letter, you can see for yourself that there's a wall connecting from one side of the house to the other. So the idea that this is detached is not accurate at all. There are screens in the breezeway, so there's air coming back and forth. I mean, you can open the windows in your kitchen on one side of the house and on the other side of the house, and there's breeze coming through there. But there's a continuous wall and a roof going across from the first floor that goes all the way across, and the roof goes from this basically across the driveway and then over to the garage, all connected as one unit. There are, on the left-hand side, this is on page 3 of the Drost letter, on the top floor there are 3 bedrooms, and the only other bedroom is behind the garage. The 5th bedroom is just a room. There's no heat in that room. It has a door that you have to go through one side to go through the other side. That's what's being counted as a bedroom. It's a tiny space, and it's full of storage stuff. I mean, it doesn't look like a bedroom at all. Nobody would walk into that room and say it's a bedroom. And under the bylaws define a bedroom by reference to the environmental protection regulations, which say that a bedroom is what it sounds like. It's a room that's primarily used for sleeping, that it requires ventilation, it has an expectation of privacy, which you definitely wouldn't have with people passing in from one side to get through the middle of your room constantly. And it cannot be used for sleeping, well, I mean, it could be, I guess, if you were, you were used to the cold. There's no heating in there, it's a dark, small space with no expectation of privacy whatsoever. So I think another thing that I wanted to point out that I think the letter actually makes clear, which works against the argument that the Drosts are making, is that this is rented historically as a second dwelling unit. So there's already a cease and desist order against the alleged unlawful use, which the wards are happy to comply with. They have never used it as a separate dwelling unit, and they're happy to continue not using it as a separate dwelling unit, consistent with the building inspector's cease and desist letter. But to ask them to tear out plumbing that's been in there for 50 years, all of a sudden, it's counter-logical. And that's not a prevention of a historical use. You can't prevent a historical use. It exists in history. It's not currently being used as a separate dwelling unit, and the wards have never used it as a separate dwelling unit.
So, can I ask a question for a moment? Can I go back to the number of bedrooms since you
Yeah.
brought it up? I'm trying to figure out whether if this is in fact a bedroom beside the garage, would it be the fourth or the fifth? So how many are you saying bedroom, exclusive of the garage, how many bedrooms are you arguing on the property?
There are 4 bedrooms in the property,
4 bedrooms, not counting the garage.
including the garage.
So the 3
So
bedrooms
there's 3
on the
bedrooms
main.
upstairs.
Yes.
3 upstairs, and then there's only 1 other bedroom in the entire lot.
And is
on
that
it.
consistent with how you're advertising it for sale?
Yes. Yes.
So our records, our tax assessor records are on, there should be a 3-bedroom house. Well, you're gonna get a big tax break on this one.
I think it was sold to the wards as a 5-bedroom, and I think that it has at certain times been used, that tiny space has had a bed in it, and I think it may have been listed that way when Mr. Ward purchased the property. And I don't know how, many other times over the past 50 years it may have been referenced as a 5-bedroom, but
Did the wards advertise it, the second dwelling we're talking about, or the garage, as a separate bedroom online?
so if you mean as a rental?
Yeah.
As a rental unit?
Yeah.
I'm not sure. No, it's always been,
Property was originally listed, it's for sale right now. The original listing was listed as a separate unit, that it had a separate unit, and they've now since changed it.
Yeah,
In-law,
right,
The
which-
MLS actually said an in-law apartment on the MLS.
yeah,
And
that was
the
brought to our
RDO
attention by the building inspector, and that's been taken down and
I think
corrected.
that's our biggest
And that's
concern.
right.
And I think that's why people are upset, because it's like, they leave, someone else comes in, and the next thing you know, it's another in-law apartment.
Right.
It's already
No, I
used as.
I understand that, and the wards have made that change and are not selling it that way. And I think purchased it with the same understanding as anybody else had. I don't think anybody prevented the wards from buying it when they purchased the property exactly as it was advertised to them. So they're putting up with the law now for a house that was advertised to them the exact same way that they initially advertised it, the way that the realtor really, and I'm not trying to assign blame on somebody else, the wards take responsibility and have corrected the error and understand that it is their responsibility to make those
So
representations, but
in the MLS, is it 3 bedrooms, or is it 4?
it's a 4-bedroom.
So you're counting the garage as a 4th bedroom?
That's correct.
Okay.
When did the wards buy the property?
In 2011, right, and then it moved into a trust, I believe, in 2015, but it's been owned by them since 2011.
I think for me, no matter what it's been advertised as, it's the fact that you leave habitable space to go through unhabitable space, because that's what the breezeway is. It's not heated, which means it's not habitable space, to go to another space. And so to me, it's considered detached.
Okay.
So, and that's only one part of, this story here. But I think if you look at the building code, it is you can define this as two separate spaces. They're not detached, they're detached by a roof, but they're not detached by habitable space, because that would have to be heated.
Well, in that case, there's no way we can say that there's 5 bedrooms, because the 5th bedroom is not heated as well. It really connects to the same breezeway space, and there's no heating units in there at all.
Is the breezeway space the same as the office space, or is that a separate, also another separate space?
The breezeway leads up into a door that has another door shortly after it, so there's a small room there, but that room is not heated at all. It's just a little step up from the breezeway, and then there's a small room.
But there's a separate office though too, right?
Yeah, and on the first floor, there was an office room that I saw.
So I mean, we can, again, by.
An office,
Yep.
office in the house or in the garage?
In the house.
That's not
Because
enclosed.
again, by the building code, there is a definition of what a bedroom is, right? You know. So
It's-
Technically-
Well, the bylaws
This has
also
been
have
an
their own
ongoing-
definition.
I mean, this has been a fight for as long as
Yeah.
I've been doing this.
yeah, no, I understand. But
What's a bedroom?
I
what
think
isn't a
when we
bedroom?
saw the floor plans previously, there were many spaces that I remember counting, there could almost be 6 bedrooms if you really wanted to. There were many spaces, so again, there's different things we're talking about here of sort of what each of you are saying, right? There's different elements, but to me, they're detached because you have to leave habitable space to go into uninhabitable space, then back into the garage. So in my opinion, they're separate.
I agree with you.
Yeah.
Okay, I mean, I understand that. It still doesn't make it a separate dwelling unit necessarily, the fact that it is detached either. It's a common wall, and you can read this in their brief, in the footnotes on the 4th page.
There is no
They say that there's a wall that runs from one side of the house through the breezeway all the way across to the other. I mean, they're connected as a unit. If you just look at the picture, it looks like one unit. I mean, there's a screen, yes, there's 5 screens, one beside the other, but it is a wall that connects one side of the house to the other.
So, Michelle, you're saying that if it's detached, it's a whole another item that's not, that should not be allowable to live in, let alone
That's correct.
just leave it as a bedroom. Take out the kitchen, take out the plumbing, it's just a whole separate space.
That's correct.
And so, you know, we don't have detached, we don't have accessory apartments
That's your point, yeah.
on Plum Island, attached or detached. The fact that it's, you know, then again, we're back in a circular loop of what's existing, when it was existing, what the use is, and what the intended use, implied use, and what the visual use is what we're trying to assess, and we're trying to pass judgment on. Building inspector passed judgment, and now somebody's appealing that judgment, and so we're really trying to understand what the building inspector said and whether that is correct or not. So going back and finding it something other really isn't the argument before us. It's really focusing on the building inspector's judgment of enforcement. And as he said, there were 2 parts to it. There were some things of connection to the garage, which was just safety and must be done. And then the second part of removing the kitchen and then leaving the space as it is for whatever use, as long as it was not rented as a separate unit. Did I mix anything there, Peter?
Well, I mean, only that, the kitchen wouldn't have to come out. You can, you know, there's precedent certainly for it.
That argument, thank you, that argument was made previously in the last presentation, and it was deemed and found that there is no building code that says you can't have a second kitchen. It's just that the second kitchen in a very suspicious location then leads one to believe that something else is going to happen, and that's where we have great issue. And the last time the applicant, his property was before us, and in order to do the addition, the request was to remove the kitchenette, which was accepted. And obviously, there were some other issues, but the property has issues, unfortunately. And so those issues are compounding the view of what it is, what it actually is, and what it can be used for. So appreciate what you're saying. I think we're thinking through this, and we're all trying to get to the understanding of what the building inspector's decision was, what is being appealed, and at the same time, we have a very confusing piece of property that adds to a lot of confusion of how we're viewing different things, and I think we need to figure out how to make sure we understand what we're actually adjudicating and approving or not approving, and that we're not drifting, but we're also trying to get to the point here. So,
That's a good question for you. Do you think it should be a bedroom? Should be a bedroom?
well, let's, do you
Are
have
we not
any?
done yet? I'm sorry.
Yeah, if you have any questions for me, anybody?
Not at the moment.
Okay, all right,
So appreciate that.
thank you.
So,
Yeah, the assessment says 4 bedrooms, I'm not sure if somebody.
That's, right, and I read that, it says 4, but it seemed like you were arguing there were 3 in the main house. That's why this is a difficult piece of
Oh,
property.
there's 3
You can't even
upstairs.
agree.
There's 3 upstairs and 1.
3 upstairs, but the assessor's card does say 4.
Well, because the 4th one is behind the garage.
That's not what it says. It says in the main house, if you read it, it says in the main house built in 1900, unless you're arguing that the garage was built in 1900.
No, we're not arguing that.
Well, then I accept your apologies.
Eric, we just had a conversation here. Do you think it should be a bedroom?
I got your question, but we'll hold that for a moment. So is there anybody else in the audience that would like to speak in favor? Seeing none, is there anybody in the audience that would like to speak against? That's not
I
your
just
turn.
want to submit,
Go ahead, I'm
no,
sorry.
I want to submit the VRBO listing that was
Yeah.
out on September 25th, 2022, and it does show 5 bedrooms, 10 beds, sleeps 14.
Can you just state your name and address,
Sure,
please?
sure. Yeah, it's Maria Casey, 328th Street.
Okay, if you'd like to.
Oh, sure, yeah.
Thanks.
It's right here. And the date.
I think we had that in the first
Yeah, we
time
did.
You
around.
probably do, but I just want to make sure for the record.
Okay, so we appreciate that.
Thank you.
Thank you. Do we need a copy of this if it's officially submitted? If we can prove that it's already in the packet, were you gonna make a copy of it? Look at Martha go. All right, we'll accept your document, we'll make a copy, we'll give you back your original, and we'll
It just
add it to
also
the
talks
record.
about the 2 kitchens and, it's kind of, if you look at the tax assessment too, it shows it's only 1 single-family home, but there are 2 kitchens in there. And I'm kind of surprised that from a tax assessment, and we know, there's a field card out there that states back in 2023, permit notes from July 23rd, 23, for repairs of the roof over the kitchenette. Also notes 2 kitchens on the field card. So the town knows that there's 2 kitchens, but still has the tax assessment as 1 family.
Thank you.
Hello, my name is Tim Drost. I obviously filed the appeal of the situation. We've talked endlessly at this. And I just want to say, a couple things. One, obviously, we have a home and that we worked extensively on and looked when we were purchasing a home that we expect, that we follow the laws and that our neighbors do, and that the town supports us in those things. And we've spent an incredible amount of money on something that we feel, and been here multiple times, something we feel that's, this conversation's a non-starter. there's no question that it's never been, so I'll start with the permit situation and to speak to the building inspector. At the end of the day, there's no permit pulled. So there's no gray area there. So ultimately, even if you building the bedroom, you deem that they can put it there, it's not into code now. What would have to happen is a permit would have to be pulled and the building would have to be built to what the code is today. Because it can't be, building code's not grandfathered. We quoted the IBE, that's only if it was lawfully done at that time, which it wasn't. So, but that's not even the argument. Ward's attorney spoke here today and said, and this is what we have a big problem with, and this is what keeps going back and forth, because the confusion of what the bedrooms are. Well, they just proved my whole argument. They came up here and stated that it's 3 bedrooms in the house. And I'm concerned that the building inspector is giving them tips of making sure what's supposed to be on the listing or not. But just a couple, let me just finish. I didn't interrupt you, okay? Just a couple of years ago, the Wards came here, brought plans to this, which you guys can pull up right now, right? 2 years ago when they wanted to build an addition. The plans that you have, that they submitted, state 4 bedrooms in the house. They drew it out, submitted it to the town, and showed the 5th bedroom when they were trying to expand that, and we had this argument. Now they're here today saying, no, it's only 3 bedrooms in the house, and the 4th one is behind the garage, and that's what's listed on the property card. But we already have the paperwork that they submitted for years and years and years, right? The town has listed it as a 4-bedroom. When they came in front of this board and asked to build a huge addition, they listed the house and drew it out and submitted it, that there's 4 bedrooms in the house and 1 bedroom in the addition. Right? We already knew that that was a problem, and we went in front of you and you said, well, that's a different matter, we're gonna have to bring it up. So it's not us, there's no argument if there's 4 bedrooms or 3 bedrooms, because they submitted it themselves to this board when they wanted to build a big addition, right? When it was working into their benefit, when they wanted to add 5 or 6 bedrooms, they were trying to circumvent the PIAD then. And today, whatever suits their argument, now it's only 3 bedrooms. So that's, obviously you can see why we would be very disappointed that we have to sit here for a couple hours and listen to this when this is back and forth depending on what position they want to go with. It's never been permitted. It's not allowed. And obviously there's clearly safety violations just from a fire safety situation. There's reasons why there's codes. There's no argument if it's a continuous roof. It's unconditioned space, conditioned space, unconditioned space. I mean, there's unconditioned space in between the 2 conditioned space. That's simple building code. There's no gray area. It's never been permitted, so it would have to be, you would have to approve that they're allowed to put an additional bedroom, which PIAD wouldn't allow. But even if you did approve it, then it would have to get a permit pulled to get the structure up to standards today. So I don't understand why we have to argue all this. It's illegal. The use is illegal. The building inspector has that they advertise it as a rental space, and it's extremely detrimental to us, to the neighbors that are here. There's 12, 14 people, right? How do you fit 14 people in the house? Because they're advertising as a 5-bedroom house that sleeps 14. We got cameras around our house, people are coming over, because there's big parties into our yard, urinating in our yard, we pick it up on the cameras. This is not a fact of their families live there forever, and their kids are in this bedroom, and hey, they're using it for a use. It's purely, they have something illegal, and they're asking you to let it be illegal, and then they're gonna sell the property, and then somebody's gonna buy that property, and we're gonna be back here again, because it's not legal. But do you think that somebody's gonna buy the property, they're listing it as a 5-bedroom house with that there, that somebody else is not gonna go through the same thing? Our rights should be protected. It's not about a neighborhood dispute, it's what's right and what's wrong. They sat here and argued in front of you tonight that it's a 3-bedroom house. 2 years ago, they were arguing that it's a 4-bedroom house with a 5th behind the garage. It's not an argument or gray area. They are the one that brought the paperwork to you. That's it. So we're obviously extremely frustrated that we have a home and we renovated our home. We bought it at the same time they did and followed the rules exact. And we have all the paper. And we expect that today, there's certainly a difference of what we were held to the standard of what is going on. As far as, I don't think that a building inspector can make a determination of a building, what the use of it is. It's whether it has a permit or not. That's it. It clearly shows it's a separate unit, and that's what should have been inspected, and it's illegal. It's not permitted. So the right thing to do is, hey, if you're gonna allow them to have a new kitchen and bedroom, then the building inspector should make them pull a permit, and it should be up to code. But it's never gonna get that far. That's what I have to say.
Can I just,
Peter, yes, you can, rebuttal.
just a couple of things. First off, I've got no dog in this fight. I've never met Mr. Ward till this all started. I've certainly not given him any tips. I'm simply telling you what I saw when I went through for an inspection regarding what was in the house. My enforcement order is to eliminate the use which was improper, in my opinion, for any rental, short-term or long-term. The age of the work that was done there is retroactive to the point where it is, again, not subject retrospectively to the code.
Only if a permit was pulled. That's it. It would have to be.
That's not the way I see it. So the space itself is not the issue, the use was the issue. The enforcement order eliminates the use, but the space is existing and it is established. That's my only, these things get a little too personal. I don't know anybody on any side. I'm just trying to.
We appreciate it.
Yeah, we appreciate that.
We appreciate it.
So I
Work
think-
through it.
I think, yeah, and we're not trying to be bad, and we're not trying to enforce, we're trying to interpret the zoning bylaws for the benefit of every resident in the area. And so we don't have a stake in any piece of property, but we understand neighbors and adjacencies, and we're trying to look out for the best of every resident when we go through this. Is there anybody else that would like to speak for or against?
June Fletchy, 72 Northern Boulevard. I've lived out on the island for 24 years now. I've run by this house a number of times. I live 2 doors from it. And I know in the summertime, there are numerous people living there. And as far as a bedroom being heated, it wouldn't make any difference in the summertime because they even sleep in the breezeway. So, as far as having a 2-family, I saw the original application they made with 2 front doors and 4 bedrooms and 2 separate bathrooms, and it was obviously an application for a 2-family house. And I'm glad that didn't pass, and I hope that you listen to the Gross, and I agree with them 100%. Right?
Thank you.
Thank you.
Okay. So with that, with public speaking, with the presentation for the rebuttal and hearing, building inspector speak before we should discuss the issues. I think Jack was trying to get down an avenue of understanding of use. And I think that what we've heard is that this is an administrative decision. Again, there were two parts to it. One part that no one's arguing with in terms of making the house safe for building codes, and then enforcing part of the zoning bylaw for a use of rental and maintaining the structure, because the structure has been there over a period of years, which is now deemed to be what's the phrase of non-conforming? It's a pre-existing non-conforming, not that it was pre-existing bylaws, but it's pre-existing now that it wasn't enforced. And so we know that the use wasn't, and the structure wasn't appropriate, but since there was no action on it, it is now appropriate. So we're focused on the use. We're focused on, or should be focused on, the administrative appeal of the use, and then now there's a challenge to that administrative use that it did not go far enough into removing that use. Right, so that's where we stand, and we're making a judgment on the administrative order and the fact that it did or did not go far enough to remove or remediate a use that is deemed not allowable, but even further action is needed to remove that possible use.
Question, do you think it should be bedroom?
In the thought that any space or room could be used as a bedroom, that any space where people can sleep then is what is used as the metric for determining the amount or the load on the sewer system and the PIOD in terms of its intent, its overlying intent of not exacerbating a density is not to exacerbate the sewer system that they put in so that the sewer system is overrun and we once again have a problem with septic on the island, is the big driver of what the PIOD is getting at. And with that, we certainly have dimensional requirements that are trying to make the property, the structures on all the properties as equal as possible so that everybody has equal rights. And one neighbor, one piece of property has the same rights as other properties. What is difficult in Newbury and what is allowable by Massachusetts General Law 40A is that the fact that when you have an existing structure, you have some rights as to the location and position that that structure has, and our PIOD tries to guide that in terms of the different sections that are in the bylaw about whether it's by right, whether it's by catastrophe, or whether you're seeking to enlarge and enhance. And so there are three separate sections that all try to govern that. The PIOD talks about use, and then it talks about what's allowed on a piece of property for the dimensional criteria. And as we had said before, we're always trying to take a piece of property, and Plum Island, if you talk about it by the town zoning standards of what's a normal lot and what the dimensional criteria is, Plum Island is pretty screwed up in terms of that. So all that said, we're here and we're focusing on the building inspector's actions and the argument that the actions were not, did not, that additional actions are needed, or the actions weren't stringent enough to remove the issue that the building inspector had cited. And the whole issue is complicated because the structure is complicated to begin with. So, I mean, if you think Mario, is it a room? I don't know if it's a bedroom, but the point that it is a space that can be used as a bedroom then is questionable. The fact that was rented and the building inspector is removing the rental and therefore it is an existing space. And again, we're not enforcement and we're passing judgment on what's presented to us is what we're basing our argument on. The fact that this is a compromised and unfortunate structure because it is a garage, it is a breezeway, it is there, it is over the property line, it is not connected, all adds to our opinion and what we're basing our assumptions on is whether the building inspector actions went far enough to remove a use. Am I making sense, or am I talking circles, or?
I understand that.
Right. I mean, are you understanding my argument and discussion points?
Yeah, I think so. I did want to just respond to a couple points if I could. I know we're getting long here.
Yeah, and is my logic making sense of where we're going or what we're trying to understand?
I think I'm following. It's essentially, we're not here asking for a permit. We're here over whether or not the building inspector's order was proper, was lawful, and whether it complies with what his duty is under the bylaws.
Yes. So if you have some short comments, we would listen to that.
Yeah, really quickly, I know we've sort of been going around on these things, just really quickly, with respect to our argument that the initial use was never permitted, we weren't referring to the PIOD permitting, we know that came in later. It is the building permit and the occupancy permit never issued, and that's relevant to this illegal use, and the Boyd case and the land court judge delves into this whole issue and explains why the lack of those permits is important, because those permits are what ensure that using this space for living area can be done safely. So it was the lack of building permits and occupancy permits and the inspections that go with it that we're certain were required in the 70s. The building code was in place then. So building permits were required and they weren't obtained. That's one point. Second point is, I don't think it really matters what the assessor's card says, and I don't actually think it matters whether there are 3 bedrooms in the main house or 4 bedrooms in the main house. What we really need to establish here is that no bedrooms in that detached garage unit are lawful. So they're not lawful, they can't be used now as bedrooms. And if some future owner comes in here and wants to rebuild the structure, they shouldn't be permitted to say, well, I got a 5-bedroom house now, and I want to build another 5-bedroom house. And unless you're clear that having a bedroom in that space is unlawful, that's what we're afraid is going to happen. It's not just a renter issue, it's leveraging off of the determination of what's there right now. There's no legal bedroom in that illegal detached unit. I guess that's all I'm going to say. If this does continue past tonight, I really urge you to digest that Boyd decision. But otherwise, I mean, I think you're heading in the right direction from what I can see, and I'm not suggesting that we continue this any longer unless you want more time to digest it. Thank you.
Any questions or comments or discussion amongst us of what we're interpreting, what's the application before us? Do we all understand that?
Yeah, the application, yes.
So, I don't like to drag things out, but I also would like to get things right, and as this is a complicated property and a complicated structure, and I think we would do as you just said, is that we're here trying to figure out not only what is right before us, but we'd like to try to make it clear what the future of this property is, so that we're not going around again and again and something kind of sort of keeps coming at us and we keep trying to talk about something. So I would like to I would like to have a motion to continue this with town council reviewing the brief that was presented. We're gonna read it, we can pass our own judgment, but I don't think we're any experts in reading a brief and totally accepting it or using it. We'd like town council's opinion of that. Second, I'd ask town council the ZBA's power to enforce and go beyond, not go beyond, but the ZBA's power to enforce.
I'm sorry.
So with that, and I don't think we have that power originally, and that's not the intent of what we have, but since it's now before us to judge the building inspector's interpretation and we're asked to pass judgment on that, then the question is how much leeway does or power does the ZBA have to enforce something in which to either accept the building inspector's judgment or go beyond the building inspector's judgment because the building inspector is enforcing something or has said to enforce something. You're appealing his enforcement or his opinion of his enforcement, and therefore now I guess the board, in my mind, has a decision of enforcement that we're trying to act upon. So it is now brought before us because of this administrative appeal. So with that, those are the two questions that we would ask town council. We already have talked about our next meeting being on March 14th. I would hope that I could sum up the points. Since we're a 3-member board with an associate member, we don't have any recourse to discuss this or clarify between us, which makes it a little sloppy in terms of these meetings, that we're really airing it out between us in front of all of you. If we were a 5-member board, we might be able to get a coffee and advance and clarify decisions by just having a normal discussion, but we can't do that. So we seem a little clunky, we are. We apologize. So at that matter, I will write something, well, yeah, I would propose a motion where the board presents those 2 items to town council. And where I'm going with this is that I will present those to Chrissy to forward on to town council. And with that, if you have the same or similar, you can forward something to Chrissy for town council. Town council will get back, and then at that point, I believe town council discussion between us, and we've been through this before, and I'm trying to make sure I get it right, that my discussion with town council is for me, my discussion to town council that is then distributed to the board is back. And so there's a little, I just need to clarify what we're asking on that. And my private notes and her public record and what we're disclosing is just making sure that we're all doing this on the up and up for the best of everybody. And so that, again, sorry to be a little clunky, but I'm just trying to explain where we're going with this, where I think we need to go with this. And Larry, if you have any comments, we welcome them certainly, and Martha, we welcome your expertise as well.
Along the grounds of discussion, I'm sorry, did you have something, Mike? Yeah, I'm sorry. Along the grounds of discussion, Eric, is there any precedent for us issuing a finding saying, for instance, that this is, whatever the applicants agree, a 3-bedroom house or a 4-bedroom house with a detached breezeway and a garage with a storage in the back, and then we could somewhat duck the question of whether or not there's a kitchenette in there because we've defined it as. Is that something that the board has ever done?
No, I think we have to answer the applicant's argument that the building inspector judgment is insufficient here, first and foremost.
Okay.
My second question about enforcement would then be, I think along the lines of what you're saying, is that we would find the building inspector's judgment to be acceptable, and that's that. We would find the building inspector's judgment to be insufficient, and we see this as there are additional arguments, and therefore we have some power to enforce something more than what the building inspector has done. So we're either accepting the building inspector's decision.
Defining it more narrowly, I got it.
Or we're defining it more narrowly, and if we're defining it more narrowly, then I think we're acting and enforcing something above and beyond, and that's what I need to clarify.
Very good.
And then, yeah, and we're in the ability to enforce. We have a lot of issues with the property that we need to make sure that we understand what we're actually allowed to enforce or not, for better or for worse. And that's, that we've had these, but not to this degree or to this level on Plum Island. It's been one little sticking point or one kind of issue, and that's that. So, with that, if there's a motion to.
Yeah. All right, I'll make a motion to continue the meeting to allow town council to review the information and to determine our enforcement.
Our enforcement and to pass judgment on the land court case.
And to pass judgment on the land court case presented.
I second the motion.
All right, is there any discussion on the motion in hand? We've got the motion. There's two items. The continuance is to March 14th, 7:30 here at Town Hall. All right, so with that, all those in favor?
Aye.
Aye. So thank you, everybody, for
Thank you.
attending and participating tonight. Chris, you got all that?
Yes.
Fingers cramping up, Chrissy? You were going at it.
All right, quickly, let's get on to this.
Don't come in Monday. 4 days. 4 days. I'm so excited not to see any of you. I put some snacks on your chair if you're going downstairs. Just some peanuts and a Hershey almond bar. I don't blame you. I want to too. Have a good weekend, Peter. Oh, yeah. Sorry, that didn't end up working well.
Now that we're bringing that up, it's kind of,
Right there. You're welcome.
right, so you should sum that up and send that to Chrissy, to ask town council if you have the understanding that you'd like clarified. And don't send it to us, send it to Chrissy, present it to town council.
Okay, number 3.
Thank you.
David and Cheryl Kroll, 3 River Street, Byfield, Mass. The applicants are requesting a special permit finding for relief from section 9710D2C, detached accessory apartment of the Newbury zoning bylaws, and any other permanent relief as may be required under the town of Newbury town zoning to allow the proposed use project in order to renovate the existing detached barn garage on the lot to convert it to an accessory apartment on the property located at 3 River Street, Byfield, Mass.
Hi there.
Hi.
Hi.
Is the applicant in the room?
We thought these were all the people that we sent out those notices.
So you've been stewing the whole time. Well,
Thank you for hanging out with us.
if you'd like to come up and present your application, please.
Why am I doing this? I'm not a talker. I'm gonna say the wrong thing. I'm really good with other things, but not this. So, Sherry, you wanna help me with this? So what we would like to do is to, I don't know how to put this in. The original thought was we want to put our mother-in-law in this garage space and not have it be a concrete floor. And then we went to the town, and the town said, there's no such thing as a mother-in-law apartment, you have to have an accessory apartment. So then we did the sort of the plan of the square foot to try to match it to what you guys want, and that's where we're at. So we're at the beginning stages of
prepping for this. It's a garage space that was run before. There's heating in it. It was used as a veterinary office and a lab room. So there's lots of plumbing in it. Electrical, heat, hot water. Our plans are to move the heat and the hot water into what would be right now there's a shed off the back of the garage. Move that in there so we can get the square feet for, to have room for a handicap bathroom, a kitchen area, and a bedroom. I mean, a bed. I don't want to say bedroom.
You're stigmatized by what came.
And on a side note, I can see, I can see what they're going through. Yeah, oh God. And I know what you guys are going through, because I've dealt with that.
Excellent, great job. Okay, so, understand that we don't have a mother-in-law apartment, that we have a detached accessory apartment. The section of the bylaw for accessory apartments couldn't be outlined anymore. Straightforward. There's a purpose and intent. There's accessory apartment applicability, there's general requirements, and then there's two separate divisions, one's for an attached, one's for a detached. And then there's a small section about deviations from the requirements that the board has to do. So if, in the past, they've printed out the section, and if one was to walk through and just read and check off every single box, then it's pretty straightforward whether you are allowed to do it or not. One of the sections is to, and in past, I've read every single line. I don't know if I want to read every single line this time, but so maybe I will read and try to not gloss over, but read the pertinent parts to make sure that we're going in the right direction here. Does that sound fine?
Yeah, we do have this paperwork and we have read this.
Okay, so you would feel that you meet everything that you're supposed to meet and that you've checked all the
Yes.
boxes? Okay, so let's double check the boxes and move through this quickly then.
Okay.
So, under purpose and intent, I'll read part C. Develop housing units in residential neighborhoods that are appropriate for households at a variety of stages in their life cycle for multi-generational households. Check. Accessory apartment applicability, which is 2. The apartment is either deemed within or detached from an existing. This is obviously detached. Accessory apartments in an accessory structure detached from an existing, new, or single-family dwelling may be authorized by the ZBA. That's why we're here. So then it goes to section 3 and section 5. 3 is the general requirements, 5 are the detached requirements. So 3, the accessory apartment will be completely separated dwelling unit that contains both a permanent kitchen and a bathroom and has its own means of egress. So in the plan that you provided, this is the apartment.
Yep.
There is a stair that goes upstairs?
Yep.
What's upstairs?
That was the office, the veterinarian office.
So is that stair being within this unit part of this apartment?
When I calculated a square foot, I don't think I included that because it doesn't, I don't think it might hedge on too many square feet, so it's not, it wouldn't be part of a living space at all.
Okay.
Yeah.
So let's park the square, we'll get to the square footage. We can discuss that. The owners of record of the residence in which the accessory apartment is created must continue to occupy at least one of the dwelling units.
Forever, till I'm dead.
All right.
We were talking about Sharon Baker.
Yeah. Think she'll last longer than I will.
That's my mother.
Okay, D. So 2D is now the gross interior floor area of the primary dwelling unit, excluding unfinished attic and basement, garage and porch, shall at least be 1,600 square feet. Is the assessor's card your existing property, and does that prove out that your house is more than 1,600 square feet?
Yes.
Where is it on the accessory?
I know it's in my notes somewhere and I checked that
Use
box.
code, land size, land. Somebody help me read the card here.
Yeah, it's,
What's your-
where are we here?
It says square feet, it doesn't.
Yeah, under the narrative description. Exterior and
Oh, 27.
2716 square feet.
All right,
Good. Thank you, Michelle.
check. Okay, so that was D. Then E says the gross interior floor area of the accessory apartment excluding unfinished attic and basement and porch shall not be greater than 35% of the gross interior floor area of the primary dwelling unit as defined in 97-10D3D above, or 1,000 square feet of gross interior floor area, whichever is less.
So I did the math, and that's 35% is 945 square feet.
Okay. The next, and let's hold on that, we'll go through as many and we'll come back to the ones that we have a question on, I think will be quickest here. No more than one accessory apartment shall be created on a lot. There shall be no more than 2 dwelling units in a structure and no more than 2 dwelling units on a single family lot. There should be no boarders or lodgers with either unit, I think you said that. The accessory apartment may not have more than 2 bedrooms, the total number of bedrooms, so that's H, and we'll just take a look at no more than 2. I, the existing house and the accessory apartment shall comply with all applicable health, safety, building applicable codes. I think that's pretty straightforward. The building inspector will enforce that. The proposed accessory apartment shall not violate any deed restrictions applicable to or the subject lot or residence. The applicant shall certify in a notarized statement that to the best of his or her knowledge that there will be no such deed restrictions. Upon approval of the decision on requesting the building permit, one would have to provide a letter of certifying that you know that there's no deed restrictions in a notified letter. Utilities such as water, electric, and gas necessary for the accessory dwelling unit shall be an extension from the existing utilities serving the principal single-family dwelling. So does power and,
So
are you in the
this-
water district?
This is where it gets a little sketchy. When the prior owner had that as an office, I think what they did was to use, for some reason, natural gas put their own meter there. So there is, in theory, 2 gas lines going into the house, but the water is ours and the electric is ours. So that's kind of the, I don't know how to remediate that. But that is a situation where there's.
Yeah, what is the thinking behind that, do you know?
So we're trying to make sure that what your intent is meets the bylaw.
Right.
We're also trying to make sure that your intent or a slightly different intent meets the intentions of the bylaw. People do things, like the last applicant, and they do it for good reason, and it seems like it's a great idea, and then they put it on the market, and somebody else thinks it's something else, or someone else tries to get value out of what is there, but it is not, it's not an approved use, or it doesn't meet the bylaws because they now use it as something differently. But they go back and say, well, it was existing. So if the utilities are separated on some properties, someone might make the argument with separate utilities that they could carve off the apartment as a separate lot or house.
Okay.
And we're trying not to get in the situation where things are done that could then happen to be or not be appropriate.
Okay.
We take that your intent is pure and noble, and we're accepting all that, and we want to help you get where you're going, but we've got checks and balances to make sure things don't happen, and it looks like a duck and it smells like a duck, and it kind of sort of a duck. You're not representing it as a duck, but we're looking at it, kind of scratching our heads, making sure that it can't. So the utilities are and have been a stickler in here, and we have had people wanting to put separate, like, electrical in there. And it also then means that if you have the utilities and you have the meter, then you're forcibly in control of the apartment and what's going on. And if they have their own meter and their own service, and they're, you know, they're growing pot plants in their second floor, and you're not watching the electric bill, then you just shrug and, you know. But that, you know, that's what it's trying to get at different levels. And again, it's not that we think, but these are the controls that really make this an accessory as opposed to a totally separate use on your property.
Okay.
Now, would that, I mean, how would that work if you decided to put a second building? I mean, you couldn't sell it as a second building, right, in theory, because we wouldn't have 2 acres, we do have 2 acres, but it wouldn't be part of the 2 acres.
Again, each one of these is trying to get at a piece
Okay.
to make sure all the little pieces are
Yeah,
checked
yeah.
and not the whole.
Okay.
And yes, if you, I don't know what the board's gonna say, but, you know, we might take that into consideration. We have a little less leeway in here, as it's not in the PIOD, and we're not judging you against your neighbors, we're judging you against the bylaw.
Yeah, exactly.
So, again, let's keep going here, but let's note that K is one of them.
Yep.
A minimum of 1 parking space. How much, I mean, you've got, how many acres?
Yeah.
You got 95,000 square feet, so I think you can find a couple parking spaces dedicated to this. All right, 4 is an attached accessory apartment, and 5 is the particulars. 5 detached accessory apartments. All right, the minimum lot size for an accessory apartment in a detached structure constructed after date of adoption of the accessory, it's not, that doesn't count because it's already there. The minimum lot size for an accessory apartment in a detached structure in existence as of the adoption of the accessory apartment bylaw, May 21st, 2013, shall be 40,000 square feet. We just said you were 95,000+ square feet. So B is checked. C, where the accessory apartments are permitted in existing detached accessory structures, any exterior modifications to the accessory structure shall be consistent with the appearance and purpose for which the structure was originally built. And if the accessory apartment is incorporated into a new accessory structure, the new structure shall be compatible in style with the principal dwelling unit, with the principal dwelling on the same lot. So, you know, we'd like properties to be harmonious and not something totally glaring different. And if it's different, then it seems more detached than it's supposed to be. And so, Mark, you drove by.
Yeah, it looks the same.
You drove by?
I did.
And when people, sometimes the apartment is on the second floor, sometimes they add stairs, sometimes they add lights, sometimes they add balconies. We just want to make sure you're not adding something that then all of a sudden affects your neighbors, that, you know, you're focused on your use, but we don't want it to affect them. The proposed building scale shall be consistent with a single-family residential character on the lot and of the surrounding neighborhood. The abutting property shall be protected from the proposed use on the site by provisions of adequate buffers, screening against lights, sight, and sound. So, you've given us a plan. Can this, or is this structure readily visible or in front of neighboring structures?
It's in their backyard, basically.
And is there screening along the road in front of this?
Yes, there's a whole,
It's not in front of, it's our driveway.
yeah, so it,
To the existing.
yeah, it goes along Nob Hill, and Nob Hill has, the town owns a certain amount of land, and then the neighbor at the top of Nob Hill owns all the land right by our house, and then we own a short period, so there's nothing but trees in between that structure and Nob Hill.
Yeah, it's kind of a corner lot on the corner. I've been by the Nob Hill.
Okay. We don't want Granny having wild parties in the neighbors. So.
It's a rough neighborhood, I'll say that.
So that brings us back to the size, the utilities, and you have an existing structure, the stairs within the structure. One would, it looks like, or it would be, that once you enter, you have the ability to go upstairs.
Yeah, what the plan is, because we were told we had to have a closet, so was to build a closet underneath the stairs.
So having a closet still makes the apartment, but the size of the apartment and the fact that you could have 2 floors and that you could then go and divide upstairs into more multiple bedrooms is a little problematic in terms of the size that's being represented in the size that we have here.
So should we block off the top of the stairs? There's a landing that is, I think, 7 stairs up.
So, I'll cut you off because I'm going to jump to it. So, 2 things. Either the stairs are separated so that you step into a vestibule, and then from that vestibule, you have the option to go upstairs, or you have the option to go into the apartment. Or the stairs come out from the interior and the stairs are put on the exterior, and the person going upstairs is not going through the apartment downstairs.
So you would have to do a vestibule, which is gonna
Take up room.
room from a very small space to begin with.
So there are no interior stairs right now from the
No, there's.
first
There
floor?
are.
They're off. Yeah, okay.
Yeah, that's what those are.
Yeah, that space where the,
So
where
is
the
there a
double,
problem?
where the entry door would be, is basically a garage space. And those stairs used to go up to where the office was.
Somebody wanting to use the space upstairs, whatever it may be, has to go through the apartment and up the stairs to access what's upstairs. So the controls and limits of trying to define the space and limiting the area of the space would mean that once this is done, and again, not that we don't trust you, but the next person coming along eyes this, sees the stairs, and all of a sudden they have double space of the apartment and more bedrooms than are allowed, and the accessory apartment with all good premises is turned into something that we are trying to limit and not have. And then we're back to enforcement. No, you had it there for 10 years, and now we have an existing nonconformity that we didn't intend to have. So we're just trying to make sure that doesn't happen, and it's not really your fault, but it's what we're after.
David, you said there's a landing halfway up or something?
Yeah.
Would it, just as an idea, not as a saying the board is making you do that, would it be possible at that landing to make the vestibule like Eric suggests and have stairs going outside the building?
Yep.
There are stairs outside the building right now.
Well, could you connect them and make a sealed thing like the chairman suggested? Would that satisfy?
Yeah, I mean, there are exterior stairs.
Right, so how do we block off the stairs inside so that the apartment truly is solely,
Well, could we block off the door that's at the top of the stairs? So that if you wanted to access the second floor of the barn, you use exterior stairs?
Or-
kind of like something a little bit more physical blocking so that, again,
Well, and you build a wall there.
Yeah, that's what I was thinking about, just taking and building a wall, going straight, right now, if you go up those stairs, correct, there's a winder that takes to the right. If you built a wall at the stair number, I don't know, 5, and did a wall straight up, that separates that area, that's done, and then you put flower pots going up the stairs, you know? Or I could just remove those stairs and leave that open
I think if
space.
you remove the stairs, the issue just totally goes away and we're off and we're totally where we're supposed to be. And we're not leaving kind of sort of something
Okay.
for somebody else to come back in the middle of the night and cut a
So-
hole and then all of a sudden we're into something that we didn't want.
So build the wall and remove the stairs downstairs from the landing.
Yes.
Is that what I'm saying? Oh, that's a good solution.
And then you just build in your little closet as you want it.
Yeah.
And we're all
Yeah, I
following
gain
exactly
some more space.
what our intent is.
Yeah.
Yeah, and you'll get more space in the apartment. Then the space, you said they were slightly over, or were we at the number?
Yeah, what, what's 23 by 23?
400.
Plus the front piece, which is 14 by 13.
29, 23 by 23?
Yeah,
By 29.
And then what's 14 by 13?
That's shed, that, what I call B and C on the back.
Or maybe 2.
Yeah, that's, right now, that the area B would be where the utilities would go. And C is basically what's there right now. It's a shed right now. That area C would be where I would now move the lawnmowers and the
Garden.
So
gardens.
again, somebody else looking at this and with door access in and back doors here, if 5, 6, 7, so you're at 700 square feet, so for the size of your house and 35%, Mario said it was like 9 something, and so you're at 700, we don't have an issue.
Okay.
So let's just counter with all that, and
Okay.
whether someone else in the future does something, we're still good.
Okay.
Okay, so that was D, that was 1C, that was 2D, that was H, and now the last remaining issue that I think that is just the separate gas line.
Is the septic an issue? Does that have to be?
Well, the condition of this is that we would ask that COMCOM is going to have to review it in order to get a building permit. And so
Yeah.
any favorable decision would have a condition that the septic system has to be brought up for the number of bedrooms that you're going to have on the property. So I don't think we need documentation now, but we can make a condition that makes sure it happens, and it's going to happen anyway with COMCOM, but we're just going to make sure it happens.
We usually make that condition.
Yeah. Yeah.
And also Board of Health, if I may.
Yeah.
Yes, so there are other boards that will effectively, it's their purview, but we're just gonna note it to make sure everyone knows that we checked the box, basically. So again, we're back to the gas. Are the gas lines, the shut-offs for the gas, are they both coming off the same street at the same location? Or is one coming up the drive and one coming off the main road?
One's coming off the main, from what I understand, I don't know where the actual lines are, but there's a shut off, but the meter on the main house is at the front center. And the shut off for the barn is on the left side of the barn. So there's definitely 2 lines that go in, you know, and I don't know how natural gas, I mean, yeah, there has to be 2 separate lines from the street somehow.
So there's 2 separate curb stops, is that what you're asking?
Yes.
Yeah, I would say
So
that.
you can probably see the caps in the street if you walk around.
Well, it's Byfield, so,
We might have paved over, is that what you're saying?
yes. Yes, like water lines and things like that.
That stop is supposed to be in the right of way and not in the street, but again, anything's possible.
Yeah, I assume,
That line, because when we call dig safe,
when they were digging up that bush.
Yep.
It went towards North Hill, didn't it? Didn't they have a little flaggies there?
Yeah, nothing comes off Mount Hill, because Mount Hill doesn't have gas, but you're saying on that side of the line, so on that side of the
I
driveway?
thought that's where,
So
yeah.
on that side of the driveway. So so there would be definitely two separate lines, one on the left-hand side of the driveway and one on the right-hand side of the driveway end. I mean, I could call DigSafe and say that I'm gonna put a fence in, and they'll come and spray their marks, and I could be a little bit more, but
So just the fact that we think there is, the issue that I'm having at the moment is that it's utilities such as water, electric, and gas necessary for the accessory dwelling unit shall be extensions of the existing utilities serving the principal single-family dwelling, period. We don't have relief from making a judgment call, kind of, sort of.
Yeah.
The fact that you've got electrical and water coming from the house is great, and would like to just overlook the gas, but our leeway in this bylaw is really just giving you a little extra size, that if you had come in, and even if you were at 1,020 and the calculation is 950, we could probably figure out how to 1,050, that's 1,020 is great. But we have had others that were, well, I guess the newer one, the building inspector can pass judgment on a new structure, and we're given the purview for existing to make sure all these other things are in compliance, especially the judgment call and whether it's in keeping with the neighborhood, which the building inspector, that's a little vague and not as definitive for a building inspector to make the judgment is why you're here. So I think if a slam dunk would be is if the gas was run from your house to this apartment.
I'm guessing that would not be a huge conversation.
Do you need to use the gas? Can you just use all, like electric heat and electric, and then you can
Yeah.
just cut and cap the gas
Yeah,
line?
'cause we were talking about,
You don't need to use it.
we were talking about putting mini splits up.
And then
And
obviously
then so the
being
thought
electric,
was to
so-
put mini splits up, but then keep the old system just in case, because they always say with mini splits, but I mean, that is a possibility.
It might not be as expensive as you think, it's digging a trench, I mean,
Yeah, it's just
you can look into it.
So if the gas was cut and capped and or the gas was run from your house and then the gas was capped, I think we just went through every single issue and there would be no issues whatsoever for what you're proposing. And the conditions would be the one about Board of Health and compound and the septic system, the removal of the stairs from the lower first floor unit, and the gas. And if those three items are stated, we can find our way to a favorable decision, I believe, or the board would likely find their way to a favorable decision without speaking for them. But you've clearly checked every single box, so there's nothing, there's no gray area except for those two items. And again, we have lots of judgment on Plum Island, the way the PIOD is written, but here it's pretty black and white. So that's where we are.
I have one question. So this is absolutely a space for my mother until, for whatever reason, she no longer needs it. What could we use this for going into the future, once she's no longer using it? Would this be something we would be able to rent?
Yes, under our bylaw.
Yes, as long as it's not transient rental, that you actually have a person living there.
Yeah, what is a transient rental? What is that?
That's like Airbnb.
Okay.
Yeah, and so you constantly have somebody else that's coming in and out of the neighborhood that's different. They're coming and going, and they're not really buying in. Your mother is associated to you. Utilities are coming off your house. You have control. you have a renter that's living there year-round, you're making a relationship with that renter, and you're not having just some random
Okay.
person come and go, and that's a little more sketchy to the neighborhood.
Okay.
So that would be the intent, but certainly, yes, it would be a rental property.
Okay.
So that it's gonna be gas and then figuring out the stair.
Yes.
Okay.
So what?
But both of them are doable. Yeah.
So,
And so the other thing is, like you said, if we decide to get rid of the gas and cut natural gas, National Grid out of that, and put a mini split, it may, cost-wise, maybe just cheaper for us to do that than to try to run out of line from the house. I'm thinking, because you, depending on who's gonna dig it. So, yeah, okay. I'm just trying to think of my options as far as my work.
so,
No. These folks.
any
No, I know.
questions or comments from the board?
No.
Larry?
No.
Mark?
For what it's worth, I don't understand that requirement for the utilities either.
Yeah. Yeah, don't.
But it's
and
there.
if that's the, that's a rule, there's
Yeah.
obviously a reason they do that. I can see if it was like totally separate, then you're talking about another building, but I talked to the prior building inspector about, we have another acre plus land on, it's a dogwood up to the right, and he gave us, he said, yeah, you can easily put another house up there. And so I was like, okay, well, there's another, you could do another house, and this is definitely a garage.
You can subdivide the property into an appropriate lot.
Yeah.
And you can do whatever you want on
Yeah,
that lot
how-
if it meets the dimensional
Yeah,
requirements.
it's just kind of weird how that is, like, the thought would be to turn that into a second building.
But someone else has a legal lot, and they have every right to do what every other resident has.
Okay.
You're adding an apartment, and again, there's some controls, there's some favorability that this is a good thing, but
Yep.
there are just some controls, and the utilities, I think, coming off the house are just to make sure that the homeowners live on site, and the homeowners have control over the apartment by having the utilities go through them.
Yeah.
And, that's a little stickler for billing them and how you rent it, but then it gives you the control.
Yeah.
It's okay, so there's nobody here for, and there's nobody here against, and speaking for this, so the board would have a discussion, and I guess I would lead the discussion that if everything can be checked off, a favorable decision can be had, and one way to do that is either to ask for changes to be made to the application and presented to us, or we could make a decision that has conditions that must be met before the decision is applicable for what we're asking for. Is that?
We could make a motion to a draft of a favorable decision? Is that what you're saying?
Yes, and that in the meantime, as we're drafting the favorable decision, if you could provide the revised drawing for the record, and if you could provide the documentation and narrative as to either abandoning the gas or rerouting the gas, then that would be part of a decision, and then that's what will be done, because then the decision goes to the building inspector would give you a building permit, and the building inspector would make sure he would enforce those two things as part of the
Are we gonna run into a problem not having interior stairs to the storage space upstairs?
No, because what I would probably end up doing, where that landing is, we put the door up, build stairs going up that way. There is a will, there's a way.
Yeah, and you can use the space up above for storage, and you won't be going through the apartment. And should you rent it to someone who's not family, you won't have to ask them permission to go get access storage. All right. So with that, for the board, I would guess I would ask for a motion that would have the conditions that we discussed in order to make what has been presented to us meet all the requirements that we just discussed.
I guess I'll make a motion to draft a favorable decision based on the criteria we discussed, stairs being removed, gas being disconnected, and the third one,
It's gas disconnected or the gas rerouted so that it meets the intent that all the utilities are off the primary dwelling.
The third one was just the standard Board of Health language.
okay, and to
We always have.
include Board of Health, septic.
Okay, is there a second?
Second?
Is there any discussion on the motion?
It's a good project.
I just think it would be helpful also just to put the square footage, just because we try to get the documentation right.
Yeah.
To put the square footage of, you have the existing down here of both floors, but this project's just for the first floor. So maybe under proposed lot, you can say, barn first floor and what the total square footage is. So it's clear, based on this plan, what's included in it.
So another condition of the decision is to clarify the application as to the square footages of the existing structure and the square footage of the accessory apartment.
Okay.
Okay, any other discussion? No. So on that motion, is there a vote? All those in favor?
Aye.
Aye. So you have a favorable decision. You have two actions that you have to take. You have a third that will come along in the process with the building inspector sending you to COMCOM to make sure that your septic system is appropriately sized.
So the actions that we're taking is a new draft, removing the stairs.
Yeah, you need a new plan because the plan gets filed as part of the decision and gets attached to your deed.
Got it.
And shows everybody what we approved. So we want a revised plan.
Okay.
We want a revised application. And we want some notification narrative as to what's happening with the gas.
Okay. So the revised application is filling out that
Yeah,
one
it's just this
page,
one,
those 2 pages?
that one right there, yeah.
Just really have to change the math on the.
Yeah, I think it's just changed them now.
Okay.
It's really just
Clarify
add
the
them,
footage.
yeah. Because, yeah, this sort of looks like you have a 2-floor detached barn
Yeah.
with,
Yeah, that's.
I know it's a little
existing
weird
building,
for
so-
the way it's laid out, yeah.
Yeah.
But yeah, I think if you just write, just under proposed, you can just write first floor of the existing barn
Okay.
for the square footage.
And I did that to Chrissy?
Yes. And if there's a,
And then we're calling dig safe or whatever to figure out, or we're just announcing our intention to do mini splits? Is that,
Yeah, I don't, we have to figure out cost, what the cost difference is to take and use ours, take a supply line off of our house, have a dig line going to the apartment, and then connect it to where the meter is.
You can just connect it to the line going out to the street, right?
we need a narrative on this drawing that says exactly what's happening with the gas. And then the building inspector can hold you to that narrative,
Yeah.
and then it will happen.
Yeah,
So whatever you deem best to make the gas not connected directly to the apartment, or, just abandon it, or run it from the house. And if that statement is on that plan, then we can check the box and the building inspector can enforce it, and we know it's gonna happen, and that's fine. If the stairs are shown like dashed in a note that says interior stairs to be removed, then the building inspector can enforce it, and we can all move forward.
So you can submit it as soon as you figure out what you want to do, decide, make your choices, submit it, we can approve it, and then you can go and do the work at your own pace.
So there's-
I know some good carpenters, David.
There's 4 weeks to March 14th, which is our next meeting. So Chrissy is pretty good at drafting the decision, and if you guys can get the plan and the application updated and back in Chrissy's hands in a timely manner, like at least a week before because that's when we announce and make the agenda for the next meeting, then you can be on the next meeting.
Okay.
And if the plan and the application say everything we just said, it should be pretty straightforward.
Okay.
All right.
We're going to continue the hearing?
So right, so we made a motion, and now this is a public hearing, even though there's no public here, but we are being recorded. And since you are submitting additional documentation, we will keep the hearing open. So we will, is there a motion
to continue the meeting till next March 14th, 7:30 Town Hall?
Yes. So is there a second on that motion?
Second, I'm in second.
All those in favor? Aye. And it just helps, I think, you and us just close this and accept additional documentation so that nobody can claim that you were sliding things in or we didn't have a chance to review it. But again, if you're meeting every single item for an attached department, there's nothing to really argue here.
Okay.
So, I'm just, a quick question about the gas meter. If we detach it, right, if we abandon it, what does that mean? Like, if we choose a second, which we were choosing, the thought in mind was to put a mini split system in there, which would be run off electric. What does that, we just say to you, yeah, we decided to do a mini split, but the gas meter's still there?
If you're gonna abandon the service, they're gonna take the gas meter and lock it out.
Okay.
And you're gonna close that account.
And at this point, this is just our intention to do this, so it's on the record, right? Like, we don't have to by March 14th have disconnected our gas.
No.
So that
You are
goes-
getting a decision. You must act on your decision 2 years from the date that so you're gonna get a decision, we have a draft, you're gonna come back, we're gonna review the draft, we're gonna accept it, we're gonna vote again to accept the final decision. At that point, it gets filed with the clerk, town clerk. There's an appeal period. After that appeal period, you can start to do what you want
Okay.
on the project. If you don't act within 2 years, the special permit and decision lapses. So you have some time, and that means up until 2 years, the very last day, you can start construction, and then you can keep going.
Okay.
And from my experience, it's cut and cap, that's what they want. They want you to cut and cap, it's not just turning the valve or anything, they want to cut and cap, so.
Right, and close the account.
Right.
That's easy. It's just,
I'm sure they want to go home, I want to go home.
oh yeah, that's
Thank
true.
you.
Sorry,
All right.
I know that feeling.
Thank you.
Thank you.
All right, I think there's anything else on the agenda, and there's nothing else to discuss, so is there a motion to
close the meeting?
Second? All in favor?
Aye.
Aye. Chrissy, we're good with the meeting and the camera.